Good afternoon, everyone. I, Ms. Pragya Shukla, Assistant Professor, IIMT College of Law, Greater Noida, welcomes you all to the today's delivery lecture schedule. My topic for today's delivery of lecture is study of the right of privacy in the production of content of mass media in India. We straight away will start with we'll start with introduction of what is right to privacy and privacy as a law. What is the concept? First of all, if we look to the image on the left hand side of this PPT, we'll see that there is a huge infringement of privacy right of even a high official or high government official by the mass media person. So that picture itself represents that how your privacy rights are violated. If we move on to the concept of right to privacy, then right to privacy as a concept is evolved from the deep and liberal interpretation of Article 21. Article 21 protects the right to privacy and promotes the dignity of the individual. In this regard, retired Justice K.S. Swami judgment, it paved the way for it, and this judgment implemented the right concept of privacy as being a part of life, right to life. If we move on more further, that what is the exact definition of right to privacy or what privacy exactly means, then we will look back to the definition which is given in Black's Law Dictionary, which says that right of privacy is right to be alone, right of a human being to be liberated from unwarranted publicity, the right to live without unnecessary imposition by the civic in issue with which the public is not unavoidably worried. It means that right to privacy does not only mean your personal information recordings and your giving of communication rights, but also it involves right to be alone as a purpose of being human being. You are free to do and you are given that freedom that it's your choice whether you want to live with within the society with certain people or you want to be alone from that society. It also includes your privacy rights. Further, we may also say that right to privacy is a multi-dimensional concept. It acquires in itself a various aspect of life. Further, we also say that the right to privacy refers to the specific right of an individual to control the collection, use, and disclosure of personal information. Nowadays, due to advance of technology, we have seen that there is a various infringement in personal information rights. Your personal informations are no more personal to you just because it is handed over to the third party at a very cheap level. Personal information could be in the form of personal interest, habits, and activities, family and educational records, communications, including mail and telephone records, medical records, and financial records also. There are many more in this number. An individual could easily be harmed by the existence of computerized data about him, her, which is inaccurate or misleading and which could be transferred to an unauthorized third party at high speed and at very little cost. Nowadays, the basic and major issue which is prevalent in today's society is that now your data is transferred to the third party at a very low cost, and that third party misuses your data at a various high levels. The convergence of technologies has spawned a different set of issues concerning privacy rights and data protection. Innovative technologies make personal data easily accessible and communicable. So there is an inherent conflict between right to privacy and data protection. This is the major issue nowadays, that your right to privacy and data protection is at stake. Data protection should primarily reconcile these conflicting interests to information. Further, the motives of there was some research done in India with regards to your privacy rights and data protection bill. The motive of this research is to outline the rising solitude concern in India and therefore the existing media norms and guidelines on right to privacy. Currently, The media is governed by different norms, like outlined by self-governing media bodies, just like the Press Council of India, the Cable Television Networks Regulation Act 1995, and therefore the Code of Principles made by the NBSA. Now, further we'll move on that what is the origin of privacy right. In previous slides, we have studied that what all privacy rights means and what all it includes. Now, if there is a famous definition given by William O. Dulles, which says we deal with the right of privacy older than the Bill of Rights, older than our political parties, older than our school system. That means that your privacy rights are much more older than your basic rights, which is given by your government. And the thought of privacy has been referred to as protracted growth throughout history. And creation of the modern privacy notion, which first appeared within the noted study in The Right of Privacy, written by Brandeis and Samuel Warren in 1890. In this paper, they outlined the right to privacy as right to be let alone, which we have focused in previous slides, that your privacy rights are not only restricted to your records or recorded data, like your personal record, your medical record, your financial record. Not only it is restricted to that, but also it includes your choice to be alone. And in spite of this, that privacy solely became a typically accepted right within this century, but privacy had existed long before this era. Privacy also features a terribly long history, and its origin already within the ancient societies is traced back. Even from a legal point of view, if we trace back the rights concept, then we will find that the Code of Hammurabi contained a paragraph against the intrusion into someone's home, or the Roman law also has the same regulation. Like even that oldest form of law, that is Code of Hammurabi, it in itself it has a paragraph which says that even the intrusion of someone in someone's home is also contained as a privacy right. You are infringing or violating that other person's privacy right by solely entering their house without their permission. And further, in evolution of this privacy doctrine, we'll talk about that how this concept or this doctrine has evolved in our country. So we'll focus on one judgment, that is Justice K.S. Puttaswamy versus Union of India, in which Justice Khanna has stated that human existence is not mere animal existence. Every person deserves to live a dignified life, and term privacy is that utmost significant factor regarding enjoyment of life. He focused on the concept that human life or human existence is above all animal existence. That major basic human rights or basic rights are given to human, which in which right there is also a right concept of privacy rights also, which provide a dignified life to the individuals for their enjoyment of life. Right to privacy has traveled a prolonged journey in order to attain the status of fundamental right in Indian Constitution. Since the 1960s, the Indian judiciary and the Supreme Court in particular have dealt with the issue of privacy both as fundamental right under the Constitution and as a common law right. The common thread through all these judgments by the Supreme Court of India has been to recognize right to privacy either as a fundamental under the Constitution or as a common law right. But to refrain from giving a specific definition before the recent landmark judgment, instead courts has decided to have it evolve on case-to-case basis. And in one case, Justice Matthew mentioned that right to privacy will therefore necessarily have to go through a process of case by case development. So he was very focused on the concept that privacy as a concept will not go through any statute or any law, but only it will be developed through case to case, and in different circumstances different privacy concept will evolve. The first case to lay down the basics of privacy rights in India was the Khadak Singh versus State of UP, where a 7-judge bench of the Supreme Court was required to check the constitutionality of certain police regulations, which allowed police to do domiciliary visit and surveillance of persons with criminal record. The petitioners so challenged that constitutionality of such provisions on the ground that they violated their fundamental rights of privacy under clause personal liberty of article 21 of the constitution of India. In this particular case, majority of the judges declines to interpret article 21 to include whether within its ambit the right to privacy is a part of your article 21 or not. But two of the judges in total have said that Article 21 is a part of that right to privacy is a part of your Article 21, making an early recognition of privacy as a fundamental right. Here only Justice Subbarao held that it is true our constitution does not expressly declare a right to privacy as a fundamental right, but he said the right is an essential ingredient of personal liberty. This particular line of Justice Subbarao makes it clear that Constitution does not has any express mentioning of right to privacy as your special right or your fundamental right, but it is embedded in the Constitution in the form of personal liberty. Next case law by which this doctrine evolves is R. Rajagopal versus State of Tamil Nadu. In this case, the petitioner was a Tamil news magazine head which had sought directions from the court to restrain the respondent, that is State of Tamil Nadu, and its officers to not interfere in the publication of the autobiography of a death row convict, Otto Shankar, which contained details about the nexus between criminals and police officers. There were certain questions which was put up by the Honorable Supreme Court, which says that first was whether a citizen of this country can prevent another person from writing his life story or biography. Second question, does such unauthorized writing infringe the citizen's right to privacy? Third question, whether the freedom of press guaranteed by Article 19, Clause 1, Subclause A, entitles the press to publish such unauthorized account of a citizen's life and activities, and if so, to what extent and in what circumstances. Further, Supreme Court in this judgment held that the right to privacy is implicit in the right to life and liberty guaranteed to the citizens of this country by Article 21, and a citizen has a right to safeguard their privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything concerning the above matters without his consent. The rule aforesaid is subject to the exception that any publication concerning the aforesaid aspects becomes unobjectionable if such publication is based upon public records, including court records. This is for the reason that once a matter becomes a matter of public record, the right to privacy is no longer subsist and it becomes a legitimate subject for comment by press and media, among others. Similarly, there are many cases which help in evolution of privacy doctrine in India. Further, we move on to a case which says that right to privacy of HIV patient. That is the case of Mr. X versus Hospital Z. In this case, the Supreme Court was required to discuss the scope of a blood donor's right to privacy of his medical records. And further, we have the next case which talks about the context of sexual identities in the case of NAS Foundation versus Union of India, in which the court read down section 377 of the IPC 1860 to decriminalize a class of sexual relations between consenting adults. In this way, we see that how our privacy doctrine evolved from Khadak Singh to R. Rajagopal to Puttaswamy case, and from X versus Hospital Z and NAS Foundation, how your privacy doctrine in different circumstances has different meaning. Now we'll look into the international law ambit, that how your international law protects your privacy rights. The basic rights to protect an individual's privacy has been enshrined in the UDHR 1948 as follows. In this Article 12 of UDHR, there is a mentioning of special privacy rights given to all members who are following UDHR. No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation, and everyone has the right to protection of law against such interference or attacks. UDHR's Article 12 states that privacy rights extends or its scope is extended to your family, home, or your known ones. Even if anyone attacks on your reputation or harms your honor will equivalent to your privacy rights infringement, and you can just go and make your rights available to you. Similarly, the same thing is mentioned in ICCPR, which is an international instrument which is protecting of rights, which also has mentioning of your privacy rights. Now we'll move on to comparative law on privacy. We'll study that how privacy law is different in different nations, in different continents, how this data protection bill works. Firstly, we'll see that there is three privacy law differences in USA and European Union. First we'll move on and we'll see that how in USA these law works and how in European Union these law work. In USA, there is an depending on an organization's term of service, they can retain and use data freely. Whereas in the European Union, law allows consumers to modify, control, or remove data collected about them. Second point, only federal privacy laws are universal nationwide, and additional privacy laws are set at the state level in USA. But in European Union, a simple regulatory power enforces a single privacy law for all 28 member countries. And last point, in USA, there is federal law mandates sites and apps for children under the age of 13 to obtain personal consent before collecting data. And European Union, there is anyone under the age of 16 must obtain a parental consent before the online services and may collect data about them. So major difference what we see from USA and EU is that their federal laws of privacy are universal in nationwide in USA, and each state wise these law changes. But in European Union, a single universal law is followed by the 28 member countries of that union. And that age factor, which in America that is 13, and till 13 of age of children, parental control is necessary, and it mandates for any site and app to be collecting the data, whereas in European Union, the age limit is set to on 60. So we have studied how these two laws are different in different continents. Now we'll move on to the US and the UK approaches for data protection and privacy laws. In US, there are certain data protection bill which we'll see. The first is Health Insurance Portability and Accountability Act, which is HIPPA, which majorly focus on healthcare sector privacy laws. Next is Graham-Leach-Billy Act, GLBA, which is concerning towards the financial service sector. Next, Right to Financial Privacy Act, RPFA, which deals with personal financial records. And lastly, there are many miscellaneous acts also, which are other indirect laws, that is Computer Fraud and Abuse Act, Electronic Communication Privacy Act, and many more. If we talk about the United Kingdom, it has Data Protection Act 1998, which deals with personal data. And also it has Regulation of Investigatory Powers Act 2000, which deals with interception of communication and other details. Then we have Privacy and Electronic Communication EC Directive Regulation 2003, which deals with telecommunication sector. It also has some miscellaneous acts like Computer Misuse Act 1990, Crime and Security Act 2001, and the Freedom of Information Act 2000, and many more. Further, we'll move on to what South African privacy laws say. The South Africa's Protection of Private Information Act, POPIA, came into result in 2020 with precisely 1 year grace amount. Organizations that already GDPR compliant will definitely have advantage in changing into compliant with POPIA. However, the two laws don't seem to be identical. The POPI Act, which replaced the Electronic Communications and Transactions Act, ECTA 2002, is based on some principles that discusses first, rules for collecting, using, and processing data. Second, ensuring the quality of the information. Third, upholding standards of transparency and openness. Efforts to safeguards against loss, damage, or destruction of data. South African privacy law, if we see in summarized way, it starts with POPI Act, and that act says that who all is agreeing with GDPR compliant will also change into a POPI Act within two. And further, this POPI Act is replaced with Electronic Communication and Transaction Act, that is ECTA Act, and it has certain principles to be followed. Next is China's privacy law, how China works and how their data protection works. In October 2020, the People's Republic of China in public discharged a draft of its personal knowledge protection law, that is PDPL. This draft has garnered a lot of attention across the planet as its extraterritorial relevance is much clearer than that of China's existing cybersecurity law. And China's most up-to-date privacy law took effect in May 2018, and the Information Technology Personal Information Security Specification apparently contains more strenuous requirements than the GDPR. The law contains provisions associated with transparency, personal right over data, and consent. Further, in 2020, the Chinese government released a draft on personal information protection law for public consultation. As expected to require effect in 2021, the PIPL will expand the legal basis for processing beyond the subject's consent, increase data subjects' rights stand more. It will be the country's first comprehensive data protection law. So we see that till 2020, there was no such privacy laws or protection laws or data protection law. First, which was came was PDPL, then further and that PDPL law was much more relevant than the China's existing cybersecurity law, and it has much more strenuous constraint to be followed than in GDPR. And further, in 2021, they are proposing to come up with some certain new information protection data, and now we see that China is also having certain privacy law with them. Now we'll move on how social media and privacy laws are connected and how it is used. But it is shocking to know that one of the largest social networking sites, Twitter, has admitted that they have scanned the contacts of all their users so that they can get more information regarding their users. Another example of this is Facebook giving contradicting statements about its own nature. On the other hand, it takes the firm stand that it owns all the contacts available, and on the other hand it grants users the right to access any contacts available. Further, in this violation, in this regards, we have certain acts in our country, in our nation, which deals with Information Technology Act 2000, and in that act, Section 66E says that there is a punishment for violation of privacy. Means if anyone violates your privacy rights, then there is a proper punishment, and especially those through social media and other things like medias. Whoever intentionally or knowingly captures, publishes, or transmits the image of any private area of any person without his or her consent under circumstances violating the privacy of that person shall be punished with imprisonment, which may extend to 3 years, or with fine not exceeding 2 lakh rupees, or with both. It says that whoever intentionally or knowingly, it this provision gives that intention is necessary, and you know that you are capturing or publishing or transmitting the image of any person's private area, then you will be charged under this section, or you will be punished under this section, that is Section 66E, and you will be liable for that punishment. Further, These are the recent WhatsApp, Facebook privacy case, or Karmanya Singh versus Union of India. There was a constitutional right were meant to deal primarily with the link between the state and people. The facts of this case are WhatsApp contains that currently Facebook is its parent company and therefore knowledge of its user is sent to the latter. Samples of the information in questions are names, phone numbers, credentials, location, status, etc. This vulnerable knowledge is also used for a variety of functions of that the users wouldn't be created attentive to, the foremost harmful one being the danger of uncalled for police investigation. It absolutely was conjointly noted that this update of WhatsApp would have an effect on a large kind of users, most of whom wouldn't even remember of the harm that may be caused to them. This case is presently unfinished before the Supreme Court, and the question of privacy is an elementary right. Was there brought up being a constitutional bench, and this bench dominated that privacy encompasses a 3-party structure, specifically intimate, public, and personal zones of privacy. Further, we move on to privacy and media law. How this privacy and media law work. There is a beautiful quote from Mahatma Gandhi that is one of the objects of a newspaper is to understand the popular feeling and give expression to it. Another is to arouse among the people certain desirable sentiments. And the third is the fearlessness to expose popular defects. The Mahatma Gandhi here wants to focus on that the media law, or basically media's major function, is divided into 3 parts. The first object of the newspaper is that to express the feelings and give expressions to your desirable sentiments, and the last is to expose or your fearlessness about the defects which is properly going into your country. Media is the medium or instrument of storing or communicating information, and media, the popular term inter alia used as press, denotes the print and electronic information carriers, the newspapers, magazines, radio, televisions, and currently includes internet as a new form of media. Media law is a legal field that refers to the following, that is advertising, broadcasting, censorship, confidentiality, contempt, copyright, corporate law, defamation, entertainment, freedom of information, internet, information technology, privacy, telecommunication, and many more things. Further, we see that there are many media trials and media victimization which is going on in our country from many time, and how media pulls up the small data into a big form, and how media, before the court gives its judgment, how it transfers its judgment in a very malicious form. Media trial is not a new term, and anyone actually, it is the most seen concept these days. Everyone watching news channels understands the power of media, and it is easy to differentiate when its power is misused and what is the actual meaning of media trial. In Jessica Lal's murder case, there is a great example of how media puts pressure on the lawyers to not take up the case from the accused side. And in the said case, senior lawyer Ram Jethmalani took up the case, but the media used headlines such as defense of the indefensible. Media trial in general sense can be considered as a contempt of court, and media has an indispensable role in a democratic country, and it is all the pillars of democracy must function independently without intervening in the function of others. And further, in this case, a 3-judge bench led by Chief Justice of India, R.M. Lodha, described the issue at a very serious and stated that to put in place, the court would consider few guidelines in order to balance interest and right of the stakeholders. And these guidelines were observed by the court are as follows. And it says that it must and it necessarily works in the ambit of law, and media should not interfere majorly in the legal obligations or law part, and it must work in their own ambit. Further, we'll see how IT Act works in data protection reform, and there are certain acts like Section 72A, Section 72, and then we have this Privacy Protection Act 1980, and it protects journalists from being required to put out over to enforcement any work, product, and documentary materials, including source, before it's disseminated to the general public. Journalists who mostly need the protection of this act are the people that are working on the stories that are highly controversial or about criminal acts, because the knowledge gathered can be useful for enforcement, as an example, and a criminal suspect may talk openly to a journalist who promises to not print her name or his name but won't attend enforcement for fear of arrest. Lastly, we have certain conclusions and suggestions also involved, that how our media laws or privacy laws are there and how it needs some improvement. And as a citizen of any country, everyone has a right to have knowledge about various events happening around the world. And this big responsibility with the media of the country, it is said responsibility comes with power and freedom. The influence of media over a trial in recent years has given some fluctuating outcomes, and the media have sometimes given a positive result in the administration of justice, but sometimes it can also cause problems for the litigants. Media trial has even sometimes led to provoke the public and created an atmosphere of mob lynching sometimes, and this major part of media is basically creating a havoc-like situation where more offenses can be seen. The media is the mirror of society. People tend to look into issues as it is portrayed by the media. Sometimes it feels that every media house only wants TRP and no one is interested in knowing what is the actual truth. And maybe it is a time for the media to regulate and follow some strict standards and ethics for journalism. And if these standards are not followed, then there should be some penal provisions and should be imposed. And the Indian media is fiercely enjoying independent journalism by the rights which is protected under Article 19, and the government is regulating the screening of the movies. But also there are some media regulations also must be there. And like in recent case of Sushant Singh Rajput mystery case, we see that how his name and the other one, the girl's name, is in the media in different forms, and how these all are without the legal part, avoiding that legal part, how they are using their names. So it is a suggestion or a suggestive form that to maintain there must be a balance of privacy and freedom of press. And so there are some suggestions that right to privacy must be included into the number of personal liberty enshrined in Article 21 of the Constitution of India, not only in personal liberty form, but it must be expressly mentioned in that part. On prior broadcasting on any scandals or any news relating to human privacy, the Press Council of India must ensure that there is no encroachment on the right of privacy of an individual. Then there must be some direct legislations that must be enacted to protect right of privacy. Then a punitive punishment or heavy cost should be imposed upon the accused, including press, in case of violation of right of privacy. And the term privacy may also be added in Article 19, Clause 2 in an expressive form as a ground for imposing reasonable restriction under the Constitution of India. Lastly, a central state committee may be constituted for controlling upon the press and protect the right of privacy of an individual under the supervision of the Supreme Court or the High Courts. Thank you, everyone. I will like to conclude my lecture here only. Thank you.